Chapter 10. Appeal. Key exam issues. Procedural issues in connection with appeal mostly fall under one of two headings: appealability and reviewability. Appealability concerns whether the action of the lower court is one that permits the case to be taken to a court of appeals at that point. Reviewability deals with what issues, once a case is before an appellate court, the court may consider, and what standard of review, de novo or deferential, governs the appellate court's consideration of the trial court's rulings. 1. Appealability. In most court systems, the main question is whether the lower court has entered a final judgment. If not, a decision is usually not appealable at that time. There are exceptions to the final judgment rule permitting interlocutory review. 1. Has the lower court granted or denied a preliminary injunction? 2. Has the lower court certified a ruling for discretionary interlocutory review? 3. Has the lower court made a ruling that qualifies as a collateral order? 4. Is the order being appealed a grant or denial of a class certification? 5. Is there a basis for review by extraordinary writ, such as mandamus or prohibition, ordinarily for serious abuse of discretion by the trial court? 2. Reviewability. What may be considered by the appellate court depends on the issue involved. A. Was the objection properly preserved, or was it waived, as by failure of counsel to make timely objection? If proper objection was not made, is there nonetheless plain error? B. Is the challenge to a ruling on a question of law? If so, review is de novo. C. Is the challenge to a finding of fact? If so, the appellate court will generally accord a degree of deference to the trier of fact. D. Is the action one committed to the discretion of the trial judge? If so, the trial court can usually be reversed only for abuse of discretion or failure to apply the correct legal standards. E. Was the alleged error one with prejudicial effect, or was it simply harmless error? A. Right to appeal. 1. Appeal reviews lower court rulings 2131. An appeal is the usual procedure for obtaining review by a higher court. The function of the appeal is to assure that the litigation has been conducted in a proper manner and that judgment conforms to the law. An appeal ordinarily does not involve a retrial of the case in the higher court, except in some systems that allow for appeal of inferior court decisions by providing trial de novo in a trial court of general jurisdiction, but rather is limited to a consideration of the rulings by the lower court in light of the record on which those rulings were made. 2. Status as right 2132. The right to appeal in civil matters is a creature of statute. A. Common Law 2133. There was no right to an appeal at common law. A writ of error could issue from a higher court, but was discretionary with that court. B. Constitution 2134. Similarly, the Due Process Clause does not guarantee a right of appeal, at least in civil cases. National Union of Marine Cooks v. Arnold, 348 U.S. 37 1954. Cobbledick v. United States, 309 U.S. 323 1940. The right to a judgment from more than one court is a matter of grace and not a necessary ingredient of justice. C. Statutory foundation of right. 1. State Law 2135. Legislation in every state creates a civil appellate jurisdiction in some court of the state. 2. Federal Law 2136. There is, likewise, a statutory right of appeal in civil proceedings in federal district court. 28 U.S.C. 1291 et seq. 3. Waiver of Right 2137. The statutory right of appeal may be lost through any of the following: A. Express waiver. B. Untimely assertion. C. Voluntary compliance with judgment, e.g., a party who pays the amount of a judgment or performs the act ordered by a decree may be held to have waived the right to appeal. However, performance must be voluntary. Where a judgment is executed by officers of the court and thereby satisfied, the judgment debt right of appeal survives. Riatono v. Yankwich, 38 Cal. 2D 1 1951. And D. Acceptance of benefits. When the plaintiff recovers a judgment and voluntarily accepts payment of the amount recovered, he may not thereafter appeal, e.g., on the ground that the award was inadequate. Schubert v. Reich, 36 Cal. 2D 298 1950. B. Courts of Review. 1. The Federal System. A. United States Courts of Appeals 2138. There are 13 United States Courts of Appeals. 12 have a territorial jurisdiction. In addition, the Federal Circuit, seated in Washington, D.C., has subject matter appellate jurisdiction in patent cases and tort and contract claims against the United States. Appeals to the Courts of Appeals come from 1. District Courts 2139. Most appeals from district court decisions are taken to the Courts of Appeals. 2. Administrative Agencies 2140. Proceedings to review decisions by many federal administrative agencies must be taken to the Courts of Appeals. B. Supreme Court of the United States 2141. The Supreme Court has a limited original jurisdiction, as authorized by Article Roman III of the Constitution. However, the court performs primarily an appellate function as follows. 1. Direct review of district courts 2142. There is a statutory right of appeal from a district court decision directly to the Supreme Court when an act of Congress requires the case to be heard and determined by a 3-judge district court, a rare thing, and the court granted or denied injunctive relief. 28 U.S.C. 1253. 2. Review of Courts of Appeals 2143. Decisions of the United States Courts of Appeals may be reviewed by the Supreme Court as follows. A. By certiorari 2144. The Supreme Court may grant a writ of certiorari before or after judgment is entered, although review before final judgment is extremely rare. 28 U.S.C. 12E541. The court has complete discretion to deny review without explanation. B. By certification 2145. A court of appeals may certify a question of law to the Supreme Court. 28 U.S.C. 12E542. This route is used very rarely, the courts of appeals generally taking the view that they have the responsibility to decide issues of federal law themselves, without seeking the Supreme Court's assistance. 3. Review of decisions of state courts 2146. The Supreme Court may also review decisions of state courts by certiorari. 28 U.S.C. 1257. A. Highest possible state court 2147. The Supreme Court will not review a state court decision, while further review is still possible in the state court system. Thus, the litigant seeking Supreme Court review must first exhaust state court appeal procedures. B. Involving federal law 2148. The Supreme Court can review a state court decision only to the extent that it involves issues of federal law. C. Distinguished state law issues 2149. The Supreme Court has no authority to review state court decisions of issues of state law. The state courts are the highest authorities on the meaning of state law, as long as state law does not infringe on matters protected by federal law. 2. State appellate systems 2150. There are substantial differences in the organization of court systems among the various states, and no particular structure can be regarded as typical. A. New York 2151. In New York, the principal trial court of general jurisdiction is the Supreme Court. 1. Appeals. There is an appellate division of the Supreme Court, which hears appeals of right from proceedings and orders of the trial courts. The appellate division is divided into 4 departments, each serving a different area of the state. 2. Highest Court. The highest court is the Court of Appeals of New York. Appeals of right to this court may be taken in constitutional matters and pursuant to various statutes. In addition, the Court of Appeals has the power of discretionary review over many types of lower court decisions. B. California 2152. In California, the trial court of general jurisdiction is the superior court, which also exercises appellate jurisdiction with regard to limited civil cases, suits formerly heard by the municipal courts. Cal. Code Civ. Proc. 904-1, 1. Appeals. The courts of appeal, which are 6 in number, each serve a separate area of the state called a district. 3 of the 6 are further divided into divisions. The courts of appeal hear all appeals of right from superior court judgments. 2. Highest court. The Supreme Court of California exercises discretionary jurisdiction over proceedings in civil cases in the courts of appeal. Review in the Supreme Court may be granted on petition for review by a party or by the court on its own initiative. A. If a case is heard in the Supreme Court, the decision of the Court of Appeal is depublished. B. The purpose of Supreme Court review is to secure uniformity of decision among the courts of appeal or to settle important questions of law. Cal. Rules of Court 8500B. C. Texas 2153. The Texas Courts of General Civil Jurisdiction are district courts. 1. Appeals. Appeals from district courts in civil cases are taken to the courts of appeal, which are 14 in number, each serving a different area and reviewing particular district courts, except that 2 courts of appeal review decisions from Houston District Courts. 2. Highest Court. Review of civil decisions of the courts of appeals is by the Supreme Court of Texas, which exercises civil jurisdiction only. Criminal appeals go to the Court of Criminal Appeals, a court of last resort, directly from trial courts in capital cases and from the courts of appeals in other cases. D. Michigan 2154. Michigan is typical of a number of states that have a unified intermediate court, the Court of Appeals, which is subject to review in the Supreme Court of Michigan. E. South Dakota 2155. South Dakota is typical of states that have only one appellate court, the Supreme Court, to which all appeals are taken. C. Appellate procedure. 1. Filing of Appeal 2156. An appeal is commenced by filing a notice of appeal. The notice is filed in the appellate court or trial court, depending on the specific court rules. The notice of appeal is a written statement that the appellant invokes the jurisdiction of the appellate court to review a specified judgment from the court below. Formality in the notice is not essential, and the instrument will be liberally construed to prevent waiver. Indeed, under Federal Rule of Appellate Procedure 3C4, which provides that an appeal must not be dismissed for informality of form or title of the notice of appeal, a document meant as an appellate brief can qualify as the notice of appeal if it is filed within the time for filing notice and if it contains the information required in a notice of appeal. Smith v. Berry, 502 U.S. 244 1992. A. But note need to name all appellants 2157. However, if there are multiple appellants, each one must be named in the notice of appeal. An attorney representing multiple appellants may satisfy this requirement by using such terms as all plaintiffs or the plaintiffs Alpha, Bravo, et al. But it must be clear which parties intended to appeal. Fed. R. App. P. 3C1. A mere use of Alpha et al. Will not suffice, and the lower court's judgment will be final as to the unspecified parties, even if it is reversed as to those specified with adequate clarity. See Torres v. Oakland Scavenger Co., 487 U.S., 312 1988. 2. Time limits. A. Federal Courts 2158. In federal court, a notice of appeal in a civil case must be filed within 30 days after entry of judgment or within 60 days if the United States is a party. The trial judge may extend this period for not more than 30 days upon a showing of excusable neglect. Fed. R. App. P. 4. 1. Premature Notice of Appeal 2159. Under Federal Rule of Appellate Procedure 4A2, a notice of appeal filed between announcement and entry of a judgment or order is treated as filed immediately after its entry. Under this rule, a premature notice of appeal ripens and becomes effective after eventual entry of judgment, even if the notice is filed with respect to a ruling that is not appealable if the decision would have been appealable if followed immediately by entry of judgment, because the party filing the notice reasonably, though mistakenly, could have believed the decision to be final. First Year Mortgage Co. v. Investors Mortgage Insurance Co. 498 U.S. 4269 1990. B. State Practice 2160. State time limits for noticing an appeal vary. In California, the notice must be filed within 60 days after notice of entry of judgment or 180 days after actual entry, whichever is later. The court has no power to extend the time. Cal. Rules of Court 8104A. C. Limits affect jurisdiction 2161. The time limits for an appeal are often jurisdictional and ordinarily cannot be waived. Example: when the district court granted petitioner's motion to extend the time to appeal denial of his habeas corpus petition, the judge mistakenly said in the order that petitioner had 2 more days to file his appeal than he actually did. Petitioner filed his notice of appeal the day before the date specified by the judge, but that was 1 day after the actual due date, and the appeal was dismissed because the time limit was jurisdictional. Even the judge's mistake could not excuse petitioner's late filing. Bowles v. Russell, 127S, CT, 2360 2007. 3. Appeal bonds. A. Cost 2162. To perfect an appeal, the appellant generally must file a bond to secure the payment of his adversary's costs on appeal in the event the judgment is affirmed. Fed. R. App. P. 7. 1. Possible constitutional limitation 2163. In limited circumstances, due process and equal protection may forbid conditioning the right to appeal upon payment of charges such as record preparation fees. MLB v. Selj, 519 U.S. 102 1996 state that allows appeal from decision terminating parental rights may not deny right of appeal because of appellant's inability to pay a $2,300 record preparation fee. B. Supersedias 2164. If the appellant wishes to stay execution of the judgment pending appeal, he must usually assure that the judgment will be satisfied if it is ultimately affirmed. This assurance may be given in the form of a supersedias bond, which is generally executed by a surety company. Fed. R. App. P. 8. 1. Possible constitutional limitations 2165. There may be a constitutional requirement that it be possible to obtain a supersedias bond. In Pennzoil Co. v. Texaco, Inc., 481 U.S. 1987, Texaco argued that the Texas requirement that it post such a bond to avoid execution of a judgment for more than $10 billion violated its due process rights, because such a bond could not be obtained. The Supreme Court held that the federal courts should not intervene in this matter, which should have been handled in the state courts. 4. Record on Appeal 2166. Review on appeal is limited to proceedings in the trial court. A. Clerk's Record 2167. It is the duty of the clerk of the trial court to assemble and transmit the record on appeal, which will include the pleadings, motions, orders, verdict, and judgment in the case. Fed. R. App. P. 11. B. Reporter's Transcript 2168. At the request of a party, the record may also include a transcription of the testimony at trial, or such portions of the testimony that the party seeks to place before the appellate court. Fed. R. App. P. 10. 5. Stay of proceedings below 2169. The taking of an appeal ousts the trial court of jurisdiction. While the appeal is pending, the trial court generally has no power to alter or vacate its judgment and limited power to make any other order or decree affecting rights of the parties with respect to the case on appeal. Cal. Civ. Pro. Code 916A. D. Rulings subject to appeal. 1. Final decision requirement 2170. Generally speaking, only a final decision may be appealed. A. General Rule. 1. At common law 2171. At common law, a writ of error could be taken only from a final judgment, i.e., a written order of the trial court, which stated the outcome of its proceedings and manifested that those proceedings were complete. A. Rationale. The purposes of the rule were: 1. To avoid the cost and delay of multiple appeals in the same action. 2. To avoid needless effort by appellate courts in considering issues that may be rendered moot by subsequent proceedings in the trial court. And 3. To avoid the demeaning effect on the status of the trial judge that results from excessive review of her decisions. 2. Modern Practice 2172. Today, the final decision rule is the basic rule, but it is subject to exceptions. A. Federal Courts 2173. Appeals to the United States Courts of Appeals may generally be taken only from final decisions of the district courts. 28 U.S.C. 2291. B. State Courts 2174. Similarly, all but a few states adhere to the final decision requirement. The notable exception is New York, which includes trial court actions involving some part of the merits or affecting a substantial right among appealable orders. NY. Civ. Prac. Law and Rules 15701A v. C. Separate Instrument Rule 2175. The final decision must also be embodied in a separate instrument that unequivocally manifests that the trial court proceeding is complete and that a disposition has been made. Fed. R. Civ. P. 58A. 3. Non-appealable orders 2176. As a result of the final decision requirement, no immediate appeal may be taken from most orders of trial courts, including such important rulings as discovery orders, pretrial orders, orders denying summary judgment, and the like. A. Orders after judgment. 1. Orders granting new trial. A. Federal Practice 2177. An order granting a new trial is not appealable in the federal courts, so that the case must proceed to retrial and a new judgment before an appeal is allowed. B. State Practice 2178. In some states, an order granting a new trial is an appealable order. Cal. Civ. Proc. Code 904-104. C. Review after second trial 2179. In those jurisdictions where an order granting a new trial is not immediately appealable, the issue may be raised on appeal after final judgment in the second trial. If the appellate court finds that the grant of new trial was improper, it can order that the first judgment be reinstated. 2. Orders denying new trial 2180. An order denying a new trial is not itself a final appealable order, but it leaves intact the final judgment from which an appeal can be taken. 3. Appealable orders 2181. An appeal may be taken from other orders made after judgment that have the effect of vacating the judgment or staying its execution. B. Extraordinary Review 2182. In exceptional circumstances, non-appealable orders may be reviewed by means of extraordinary writs. See Infra 22E47. C. Orders not immune from review 2183. The fact that an order is not immediately appealable does not mean that it is immune from review. If a judgment adverse to the party aggrieved is later entered, an appeal from the judgment can contest the correctness of the previous non-appealable order. As to some orders, such as discovery orders, it is unusual for an appellate court to find that they were sufficiently prejudicial to warrant reversal. B. Jurisdictional character of Rule 2184. The final decision requirement is jurisdictional in the sense that it cannot be waived by the appellee. Thus, an appeal taken from a non-appealable order will be dismissed by the appellate court sua sponte. In re grand jury subpoenas Duces Tecum, 85 F3D 372 8th Sir, 1996. 2. Exceptions to final decision requirement. A. Partial final decisions 2185. If multiple claims or parties are involved in the action, an order disposing of fewer than all of the claims ordinarily is not a final judgment and, hence, is not appealable until the remainder of the claims are disposed of. Fed. R. Civ. P. 54b. 1. Appeal at discretion of Trial Court 2186. However, if the trial judge finds that there is no just reason for delay, he may enter a partial final judgment, which is then appealable. Fed. R. Civ. P. 54b generally. This power is exercised only when hardship would result if the appeal from the partial disposition were delayed. Cullen v. Margiotta, 618 F2D 226 2D Sir. 1980. 2. State Practice 2187. State rules often permit an appeal where the claims of a single party are severed and determined apart from the others. Cal. Civ. Proc. Code 579. B. Review of equitable remedies. 1. In Chancery 2188, the final decision rule was not applied in early equity practice. One reason was that equity often issued personal orders to the parties which, if erroneous, might result in consequences that could not be corrected later by review. Therefore, immediate appellate review was permitted, even as to interlocutory orders. 2. Modern Statutory Exception 2189. Modern practice generally preserves the right to interlocutory review of equitable remedies that are not final orders, but which might result in irreparable consequences. Thus, 28 U.S.C. Section 1292A provides the following exceptions to the final decision requirement. A. Interlocutory orders granting or denying injunctions. B. Orders appointing receivers. C. Decisions in patent infringement actions that are final except for in accounting. And D. Certain orders in admiralty proceedings. C. Ruling on remand of case under Class Action Fairness Act 2190. When a case is removed from state court to federal court under the Class Action Fairness Act C. Supra. 322, an order granting or denying a motion to remand to state court may be reviewed if application for review is made to the Court of Appeals not less than 7 days after entry of the order. 28 U.S.C. 2453 C1 note. Congress probably meant to say that review must be sought not more than 7 days after entry of the order. See, e.g., Morgan v. Gay, 466 F3D 276 3D Sir. 26 construing not less than to mean not more than, in keeping with the apparent congressional intent to avoid possible abuses. D. Liability determination in removed multiparty. Multiforum cases 2191. In cases removed from state court under the Multiparty, Multiforum Trial Jurisdiction Act C. Supra. 323, if the district court issues an order determining liability and certifies its intention to remand to state court, an appeal may be taken within 60 days after that order is entered. 28 U.S.C. 1441 E3. E. Discretionary Review 2192. Interlocutory appeals may also be permitted by leave of court. Thus, 28 U.S.C. Section 1292b permits an appeal if I. The trial court certifies that a determination by the appellate court of a controlling question of law as to which there is substantial ground for difference of opinion would speed the ultimate resolution of the case. and Roman II. The Court of Appeals grants leave to appeal. 1. Entirely discretionary 2193. The Court of Appeals may decline leave to appeal for any reason, including calendar congestion. 2. Re-examination of propriety of certification by District Court 2194. Some courts of appeals also feel bound to re-examine the determination of the District Court that an immediate appeal is warranted under the statute. See, e.g., Garner v. Wolfenbarger, 433 F2D 117 5th Sir. 1970. 3. Rationale for Review 2195. When the district court is genuinely uncertain about the correct interpretation of the law, and it would materially advance the conclusion of the litigation to have this uncertainty cleared up, deferring appellate review would not be desirable. 4. Scope of appellate jurisdiction 2196. Appellate jurisdiction extends to any question included within the order certified for review, and is not limited to the particular question formulated by the district judge. Yamaha Motor Corp. v. Calhoun, 516 U.S. 199 1996. F. Orders regarding class certification 2197. Interlocutory orders granting or denying class certification may be reviewed immediately if application for review is made within 10 days. Fed. R. Civ. P. 23F. Although this resembles the discretionary review available under 28 U.S.C. Section 1292 B.C. Supra. 209220 and 96. It differs in that district court certification is not required. The appellate court has complete discretion to determine whether to accept the application for immediate review. See Blair v. Equifax Check Services, Inc., 181 F3D 832 7th Sir. 1999. Immediate appeal, usually warranted only in cases in which a denial of class status is death knell of suit, because the individual plaintiff's claim is very small. Roman II grant of class status raises the stakes so much that the defendant will feel compelled to settle, or Roman III an immediate appeal will clarify a fundamental issue of law. And see Waste Management Holdings, Inc. v. Mowbray, 208 F3D 288 1st Sir. Restricting third category to cases in which an immediate appeal will resolve an unsettled legal issue important to other cases and likely to escape appellate review if deferred until final judgment. G. Collateral Orders 2198. A qualification established by case law in the federal courts allows an immediate appeal from orders that are final with respect to certain collateral matters. Cohen v. Beneficial Industrial Loan Corp. 337 U.S. 541 1949. For a collateral matter to be reviewed, the following requirements must be met. 1. Important issue completely separate from the merits 2199. The issue resolved by the court's order must be an important one that is completely separate from the merits of the underlying case. Rationale. The proper time to review all decisions related to the merits is after final decision of the case, and unimportant matters do not justify circumvention of the finality requirement. Example requiring derivative suit plaintiff to post security for expenses. In a derivative action, the district court decided that federal rather than state law should apply to determine whether plaintiff must post a bond to secure defendant's costs of litigation. This decision was appealable because it raised issues of choice between state and federal law, which were completely separate from the merits of plaintiff's claims of misconduct by corporate officers. Cohen v. Beneficial Industrial Loan Corp. Supra. Example: involuntary medication of criminal defendant to render him competent to stand trial. An order that defendant, who was charged with fraud and attempted murder, be given antipsychotic medication involuntarily could be appealed immediately. The issue raised whether defendant had a right to refuse medication was important and completely separate from his guilt of the crimes charged, and the harm defendant sought to avoid could not be undone by acquittal. Selby, United States, 539 U.S. 166, 2003. Compare order refusing to certify class. The decision whether to certify a class is closely tied up with the merits of the case, in the sense that the court must make a decision whether there are common questions of law and fact, and whether the common questions predominate in a Rule 23b3 class action. Thus, the decision was not immediately appealable as a collateral order. Coopers and Librand v. Livesay, 437 U.S. 463, 1978. However, the subsequent adoption of Rule 23F, permitting immediate review of class certification orders in the discretion of the Court of Appeals C. Supra, 2197, provides a new avenue for review of such orders. 2. Order effectively unreviewable on appeal from final judgment 2200. Early review should be allowed only if deferring review until entry of final judgment would effectively destroy the appellant's claimed rights. A. Illustration denial of official immunity 2201. An order rejecting a government official's claim of immunity from suit could not be reviewed effectively on appeal from a final judgment because the immunity is designed to protect the defendant from having to stand trial. Osborne v. Haley, 127 S. CT 881 2B and 7. Immunity is a measure designed to immunize covered federal employees not just from liability, but from suit. 1. But note inapplicable to denial based on finding of sufficient evidence 2202. When a defendant seeks summary judgment based on a fact-related official immunity defense, asserting that the record shows insufficient evidence of a genuine issue for trial, as opposed to a legal basis, such as that given facts show no violation of clearly established law, denial of the motion is not appealable. Johnson v. Jones, 515 U.S. 304, 1995. 2. Multiple appeals allowed 2203. If a defendant's Rule 12 motion to dismiss based on official immunity is denied, he may appeal that ruling and then appeal a second time if the district court later denies a Rule 56 motion for summary judgment on immunity grounds. Behrens v. Pelletier, 516 U.S. 299, 1996. 3. Not required in State Court 2204. State courts need not follow the rule of Mitchell supra, and thus may decline to allow interlocutory review of denials of qualified immunity. Johnson v. Fancal, 520 U.S. 911, 1997. State provisions regarding appellate review did not confer right to immediate review of denial of official immunity. 4. Inapplicable to judgment bar and tort claims actions 2205. The judgment bar that forbids suits against government agents after judgment is entered in the government's favor in an action under the Federal Tort Claims Act is not analogous to official immunity, and denial of such a defense does not qualify for immediate appellate review. Will v. Halleck, 546 U.S. 345, 26. B. Illustration 11th Amendment Objection 2206. An order rejecting a claim of immunity from suit under the 11th Amendment could not be effectively reviewed after final judgment because the value of the protection afforded by that amendment against suit in federal court would be lost if the litigation proceeded past the motion stage. Puerto Rico Aqueduct and Sewer Authority v. Metcalf and Eddy, 506 U.S. 139, 1993. C. Distinguish order refusing to disqualify counsel 2207. An order refusing to disqualify counsel for an alleged conflict of interest can be reviewed after trial is completed, at which time the actual course of events will permit a better judgment of whether there was a conflict. Firestone Tire and Rubber Co. v. Risjord, 449 U.S. 368, 1981. Whether counsel sacrificed interests of his client to earn business from defendant's insurer. D. Distinguish refusal to enforce forum selection, Clause 2208. An order refusing to dismiss on the ground of a contractual forum selection clause could be reviewed effectively after final judgment, because defendant objected only to defending in a particular place, and not to having to defend at all. Laurel Lines, Inc. v. Chasser, 490 U.S., 495 1989. E. Distinguished Discovery Sanction Against Counsel 2209. A Rule 37 discovery sanction against counsel will often be inextricably intertwined with the merits of the action because review would require assessment of the completeness of the discovery responses in question. Thus, such an order can be reviewed after final judgment. Cunningham v. Hamilton County, 527 U.S., 198 1999. 3. Conclusively determines disputed issue 2210. The collateral order rule requires that the trial court have made its final decision on the issue challenged on the appeal. Rationale: if the trial court has not had its final say, the appellate court should not interfere. Example order imposing notice costs on defendant. In a class action, an order imposing on defendant 90% of the cost of notifying class members of their right to opt out was held to be the trial court's final determination of this issue. Eisen v. Carlisle and Jacqueline, Supra, 1-151. 4. Exception narrowly limited 2211. The Supreme Court has repeatedly emphasized that the collateral order exception applies to a small class of cases. Cohen v. Beneficial Industrial Loan Corp. Supra, 2099, and it has been used in a restrictive manner. Example discovery orders involving privileged material. Discovery orders compelling disclosure of allegedly privileged material seem to satisfy the requirements of the rule, because they conclusively determine claims of privilege, which are separate from the merits, and which cannot effectively be reviewed after the materials are turned over to the opposition. Nevertheless, the court has adamantly refused to entertain appeals from such orders, noting that the party resisting discovery could refuse to comply, be held in criminal contempt, and appeal immediately from the judgment of criminal contempt. See Supra, 1667-1675 for discussion of appealability of discovery rulings. 5. No pendent party appellate jurisdiction 2212. An appellate court that has appellate jurisdiction over a collateral order against one party ordinarily may not exercise pendent appellate jurisdiction over otherwise unappealable interlocutory orders against other parties in the case, even though that might result in judicial efficiency. Swint v. Chambers County Commission, 514 U.S., 35 1995. H. Practical construction of finality, 2013. The Supreme Court has stated that it will accord a practical rather than a technical construction to the finality requirement. Gillespie v. United States Steel, 379 U.S., 148 1964. However, this does not cause a significant expansion of appealability. Example: death knell doctrine. The Supreme Court rejected a plaintiff's argument that refusal to certify a case as a class action is final the death knell, where the named plaintiff cannot afford to maintain the action alone. Coopers and Lebrand v. Livesay, Supra, 2099. E. Scope of appellate review. 1. In general, 2214. Appellate review must be sufficiently broad to assure that the trial court properly applied the controlling substantive law and that the procedure conformed to the applicable standards. However, appellate review does not extend to retrying the facts or supplanting the trial judge's decision in matters committed to her discretion. 2. Findings of fact subject to limited review 2215. It is not the function of an appellate court to make factual determinations. Yet the appellate court must examine factual determinations to assure that the trial court has not rested its decision on insupportable factual assumptions. A. Jury verdicts 2216. When the findings below are embodied in a jury verdict, the role of the appellate court is essentially the same as that of the trial judge, i.e., to oversee the jury's adherence to the law. 1. Substantial evidence test 2217. The accepted test is that a jury verdict must be upheld if supported by substantial evidence, so that reasonable jurors could have found as they did, even if the reviewing judges think they would have found differently as triers of fact. 2. Cases taken from jury 2218. When the trial judge has taken the fact-finding function away from the jury, e.g., by granting a motion for judgment as a matter of law, the appellate court must examine the record to determine whether there is any substantial evidence to support a finding contrary to that of the trial judge. If it finds such evidence, the judgment will be reversed. B. Judicial findings in non-jury trials. 1. Explicit findings required 2219. When a case is tried without a jury, the trial judge usually is required to make explicit findings of fact in order to facilitate review of her decision by the appellate court. Fed. R. Civ. P. 52A1. 2. Clear Error Test 2020. A judge's finding of fact may not be set aside unless the appellate court finds that it is clearly erroneous. To find clear error, it is not enough that the appellate court is convinced that it would have decided the case differently. Anderson v. City of Bessemer City, 470 U.S. 564 1985. Rather, the reviewing court must be left on the entire evidence with the definite and firm conviction that a mistake has been committed. United States v. United States Gypsum, 333 U.S. 364 1948. Due regard must be given to the opportunity of the trial court to appraise the credibility of the witnesses. Fed. R. Civ. P. 52A6. Although the requirement of deference is not limited to findings that rest on credibility determinations. Anderson v. City of Bessemer City, Supra. A. Distinguished Substantial Evidence Test 2221. The clear error test is less restrictive than the substantial evidence test, since a finding may be clearly erroneous, even though there is substantial evidence to support it. 1. Rationale. A jury verdict is the product of a deliberative process and reflects democratic political values that assign special worth to the participation of lay decision-makers. On the other hand, the findings of a trial judge are the product of a single mind, which may be more vulnerable to bias or idiosyncrasy. Still, considerable deference to trial judges' fact findings is due because of the judge's expertise in fact determinations and the costs of extensive review to the parties and to the system. Anderson v. City of Bessemer City, Supra. C. Fact and Law Distinguished 2022. It is only findings of fact that are entitled to deference. 1. Errors of Law Jury Trial 2023. If the jury was erroneously instructed on the law, the verdict cannot stand, even if there is substantial evidence to support findings that could have been made pursuant to correct instructions. 2. Erroneous conclusions non-jury trial. A. Explicit conclusions required 2224. In a non-jury trial, the judge must state conclusions of law, either in a recorded oral statement or in writing, in order to facilitate appellate review. Fed. R. Civ. P. 52A1. B. Effect of erroneous conclusions 2225. If the conclusions are erroneous, so that the judge's findings rest on a false legal premise, the judgment cannot stand, even if the findings themselves are not clearly erroneous. 3. Mixed issues of law and fact 2226. The distinction between a finding of fact and a conclusion of law is not always clear. Sophisticated observers have long noted a circularity in making this distinction for purposes of appellate review, i.e., matters may tend to be treated as issues of fact if the appellate court feels less competent to resolve them, and as issues of law if the court feels competent to resolve them without help from the lower court. A. Interpretation of legal documents 2227. The interpretation of a contract, deed, will, or other legal document is generally regarded as a question of law if the trial court interpreted the document without judging the credibility of extrinsic evidence. If so, the appellate court may disregard any conclusions reached by the trial judge as to the meaning or effect of the document and substitute its own interpretation. Cordy Allen v. Halloran, 470 F3D 25 1st Sir. 26. 1. Distinguish findings based on documentary evidence 2228. Note the difference between review of legal documents e.g., contracts, wills, and review of documentary evidence e.g., receipts, letters. Findings of fact based on documentary evidence or on oral evidence are reviewed under the clearly erroneous standard. Fed. R. Civ. P. 52A. Anderson v. City of Bessemer City, Supra, 2021, disapproving the much-cited contrary case of Orvis v. Higgins, 180 F2D 537 2D Sir, Cert, denied, 340 U.S., 810 1950. B. Negligence 2029. It is arguable whether a finding of negligence represents a legal or factual conclusion. See Supra 681, regarding pleading of negligence. In either event, appellate courts generally defer to a jury determination on negligence, even when there is no dispute as to the basic events. 1. But note, in a non-jury trial, the judge's findings with respect to negligence are subject to the clear error test Supra. See Other issues suggested approach 2230. In other areas, a question usually will be treated as one of fact if it I. pertains to the occurrence or non-occurrence of a past event. Roman 2. Is of specific interest to the parties to the dispute and has no bearing on the rights or liabilities of others. Roman 3. Is determined on the basis of the testimony of witnesses. Roman 4. Is not appropriately determined by reference to general policy. V. Is determined on the basis of intuitive instinct about the application of some general morality to a specific event. Example: one business person transfers a new automobile to another. Whether the transfer results in taxable income to the recipient or instead is a gift is an issue of fact. Commissioner of Internal Revenue Duberstein, 363 U.S., 278 1960. 1. Criticism. Reliance on the intuition of the trier of fact in such matters is the result of judicial unwillingness or inability to formulate explicit rules of decision to govern future-like cases. 3. Review of discretionary rulings 2231. Especially with regard to procedural matters, many decisions by trial judges are entrusted by law to their discretion. In such cases, an appellate court will not substitute its discretion for that of the trial judge in the absence of clear abuse. Example: whether to delay or continue a trial on account of the unavailability of a witness is a matter for the discretion of the trial judge. Napolitano v. Compagnia Sudamericana de Vapores, 421 F2D 382 2D Sir. 1970. Likewise, setting the amount of a security bond to be required of a party seeking a preliminary injunction is a matter of discretion. Fed. R. Civ. P. 65C, and whether to grant a new trial on the ground that the verdict is contrary to the weight of the evidence is within the sound discretion of the trial judge. Although the modern trend is away from earlier rulings that the trial judge's discretion was virtually unlimited. Coffrin v. Hitchcock Clinic, Inc., 683 F2D 5 First Sir, Cert. Denied, 459 U.S., 1987-1982. A. Limitation 2232. The appellate court may properly review a discretionary ruling by a trial judge to determine whether she has abused her power. Allies Chalmers Corp. v. Philadelphia Electric Co., 521 F2D 363D Sir. 1975. 4. Harmless error standard. A. General Rule 2233. The appellate court may not reverse a lower court judgment unless the trial court committed an error that was prejudicial, i.e., one that affected the substantial rights of the parties. Fed. R. Civ. P. 61. 28 U.S.C. 2111. State law is similar. For example, the California Constitution provides that no judgment shall be set aside for any error as to any matter of pleading or procedure, unless after an examination of the entire cause, including the evidence, the appellate court shall be of the opinion that the error resulted in a miscarriage of justice. Cal. Const. Art. Romans 6:13. Example: harmless. Erroneous rulings on the pleadings or on matters of discovery will rarely be sufficiently prejudicial in their effect on the trial that a reversal would be warranted. Example: harmless. The admission of improper evidence in a non-jury trial is generally regarded as harmless, since it is assumed that a professional trial judge will discount the improper evidence and not permit it to influence his findings of fact. First American State Bank v. Continental Insurance Co. 897 F2D 319 8th Sir. 1990. B. Burden 2234. The burden of showing prejudice is usually on the party claiming it. There is no presumption of an impairment of substantial rights merely from the fact that error occurred. C. Distinguished Jury Verdict 2235. The rule is to the contrary in jury trials. It is assumed that jurors will be influenced by improper evidence, at least if they are not cautioned by the trial judge to disregard it. D. Limitation 2236. The harmless error rule will not prevent reversal where the error is egregious. In such cases, the appellate court may reverse as a means of disciplining the trial judge, even though her error would not likely have had an adverse effect on the rights of the appellant. Thiel v. Southern Pacific Co. 328 U.S. 217 1946. Discrimination in selection of jury panel. E. Legal theory sustaining judgment 2237. An appellate court may review a legal theory not previously presented to the trial court if considered for the purpose of sustaining the decision below. Thus, if the findings of fact below clearly support application of the correct legal principle to reach the result achieved below, the judgment will be affirmed even if the correct legal theory was never presented to the trial court. Any error in articulation of legal theory was harmless. Zilog Itsep v. City of Agora Hills, 24 Cal. App. 4th 620 1994. 5. Waiver of objections in lower court. A. General Rule 2238. An appellate court may not reverse a judgment to correct an error that might have been avoided or corrected had the appellant made timely objection in the trial court. Security Pacific National Bank v. Giernert, 199 Cal. App. 3D 14425 1988. Rationale. The appellant should not be permitted to withhold objection and await the outcome of further proceedings before deciding whether to take advantage of a mistake by the court. B. Specific applications. 1. Jury Instruction 2239. An error in the instruction of the jury usually will not be the basis for reversal unless the appellant made a timely objection to the charge and proposed a correct instruction. Fed. R. Civ. P. 51D1. 2. Admission of evidence 2240. Similarly, an error in the admission of evidence generally will not be grounds for reversal unless the appellant made a timely and specific objection to the admission. 3. Invited error 2241. If the aggrieved party induced the error of the trial court, e.g., by proposing incorrect jury instructions or by offering inadmissible evidence, the case for waiver is strongest. Horsemen's Benevolent Association v. Valley Racing Association, 4 Cal. App. 4th 115 and 38 1992. 4. New Matter 2242. Newly discovered evidence, evidence of jury misconduct, or other matters coming to light after trial may not be presented directly to an appellate court. Such matters must be presented to the trial court by motion for a new trial or for relief from judgment. CFED. R. Civ. P. 60B2. C. Exceptions 2243. An appellate court may review notwithstanding the failure of an appellant to make timely objection in the following situations. 1. Subject matter jurisdiction 2244. When the court below lacked subject matter jurisdiction, No objection is necessary, since the jurisdictional issue can be raised belatedly or even sua sponte. Fed. R. Civ. P. 12H3. 2. Clear and fundamental error 2245. No objection is necessary when the error is so clear and fundamental that the trial court should have avoided it, even without timely objection, and it would be unjust to permit the judgment to stand. Example: in the course of a long trial, the judge took a long recess for his own vacation, causing a serious hiatus in the presentation of the case to the jury, where the judge declared that under no circumstances would he consider a change in his plans. No objection was necessary to preserve the issue on appeal. Citron v. Aero Corp. 377 F2D 753D Sir, Cert. Denied. 389 U.S. 973 1967. 6. Trial de novo 2246. Legislation may sometimes authorize a trial de novo, which is in effect a new trial in a higher court. This form of review is generally limited to review of trial courts that exercise minor jurisdiction, e.g., small claims courts, and that make no records of their proceedings. F. Appellate review by extraordinary writ. 1. Prerogative writs 2247. In exceptional cases, review of non-appealable orders may be had by means of a prerogative writ issued by the appellate court to direct the conduct of trial judges. The available writs, depending on the court system, are: A. Mandamus, an order directing the judge to perform her legal duty, and B. Prohibition, an order enjoining the judge from conduct that exceeds her lawful authority. 2. Source of power to issue writs. A. State Courts 2248. Writs in state court tend to be based on common law practice. In some states, statutes or constitutional provisions establish alternatives. In Michigan, for example, the appellate courts have power to issue writs of superintending control. B. Federal Courts 2249. The United States Courts of Appeals have power to issue prerogative writs by reason of statute, which authorizes all federal courts to issue writs as necessary in aid of their respective jurisdictions and agreeable to the usages and principles of law. 28 U.S.C. 11651a. 3. Discretionary character of Writ 2250. An important distinction between writs and an appeal is that the issuance of a prerogative writ is always discretionary with the appellate courts. The petitioner has no right to a hearing. Kerr v. United States District Court. 426 U.S. 394 1976. 4. Grounds for issuance. A. Conduct exceeding limits of power 2251. A prerogative writ may issue to prevent misuse of judicial power, such as 1. An abuse of discretion. 2. An excess of jurisdiction, or 3. A refusal to exercise jurisdiction. B. Necessity for immediate review 2252. Where the petitioner has no right to review by appeal at the present time, and would suffer undue hardship or substantial prejudice if appellate review was delayed until after a final judgment, a writ may properly issue. 1. But note, extraordinary writs will not issue where adequate review by appeal is available to the petitioner. In Re McDonald, 489 U.S. 180 1989. 5. Common uses of Writ 2253. United States Courts of Appeals use discretionary writs. A. To correct the erroneous denial of a right to jury trial. Beacon Theaters, Inc. v. Westover, 359 U.S. 519-59. B. To prevent improper delegation of judicial power with respect to special matters. Labai v. House Leather Co., 352 U.S. 249 1957. And C. To prevent unlawful remand to state court of actions properly removed to federal court. Thermtron Products, Inc. v. Hermansdorfer, 423 U.S. 336 1976. 6. Supervisory mandamus 2254. In rare circumstances, mandamus may be used to resolve issues of first impression that may be important in a significant number of cases. Silva v. Superior Court, 14 Cal. App. 4th 562 1993. Example. Where the question of the proper treatment of physical examinations of defendants under Federal Rule 35 was presented. Mandamus was available to review an order requiring a defendant to submit to a physical examination, because issue had never been resolved. Schlagenhoff v. Holder, 379 U.S. 104 1964. A. Availability 2255. In a few jurisdictions, such as California, the grounds for issuing prerogative writs have been greatly expanded. In effect, the writ proceeding becomes a device for granting or refusing immediate appellate review of important interlocutory orders. Omaha Indemnity Co. v. Superior Court, 209 Cal. App. 3D 182 66 1989.